Welcome to Supreme Court Opinions. In this episode, you'll hear the court's opinion in Dubin v. United States. In this case, the court considered this issue. Does a person commit aggravated identity theft anytime they mention or otherwise recite someone else's name while committing a predicate offense? The case was decided on June 8, 2023. The Supreme Court held that a person commits aggravated identity theft if he uses another person's means of identification in relation to a predicate offense when the use is at the crux of, rather than merely peripheral to, what makes the conduct criminal. Justice Sonia Sotomayor authored the majority opinion of the court. The meaning of each of the two key phrases, uses and in relation to, depends heavily on context. First, the very title of Section 1028A01, Aggravated Identity Theft, suggests that identity theft is at the core of that provision, particularly in contrast to a neighboring provision with a much broader title and scope. The language of 1028A01 further supports this reading. The provision applies when a defendant knowingly transfers, possesses, or uses another's identification without lawful authority. From this context, it is clear that uses refers to conduct akin to theft, rather than its broader meaning of virtually any function. Finally, the list of predicate offenses suggests that the means of identification is at the crux of the underlying criminality, not just a peripheral feature. Justice Neil Gorsuch authored an opinion concurring in the judgment, in which he argues that the statute is too vague, and the majority's opinion does little to clarify its meaning. The opinion is presented here in its entirety, but with citations omitted. If you appreciate this episode, please subscribe. Thank you. Justice Sotomayor delivered the opinion of the court. There is no dispute that petitioner David Fox Dubin overbilled Medicaid for psychological testing. The question is whether, in defrauding Medicaid, he also committed aggravated identity theft, triggering a mandatory 2-year prison sentence. The Fifth Circuit found that he did, based on a reading of the statute that covers defendants who fraudulently inflate the price of a service or good they actually provided. On that sweeping reading, as long as a billing or payment method employs another person's name or other identifying information, that is enough. A lawyer who rounds up her hours from 2.9 to 3 and bills her client electronically has committed aggravated identity theft. The same is true of a waiter who serves flank steak but charges for filet mignon using an electronic payment method. The text and context of the statute do not support such a boundless interpretation. Instead, Section 1028A01 is violated when the defendant's misuse of another person's means of identification is at the crux of what makes the underlying offense criminal, rather than merely an ancillary feature of a billing method. Here, the crux of petitioner's overbilling was inflating the value of services actually provided, while the patient's means of identification was an ancillary part of the Medicaid billing process. David Dubin helped his father manage a psychological services company. This company submitted a claim for reimbursement to Medicaid for psychological testing by a licensed psychologist. In fact, however, the claim overstated the qualifications of the employee who actually performed the testing, and who was only a licensed psychological associate. This falsehood inflated the amount of reimbursement. Petitioner also changed the date on which the examination occurred. Even with the inflation, the total reimbursement was only $338. Petitioner was accordingly charged with healthcare fraud, a federal offense under 18 U.S.C. Section 1347. According to the government, however, petitioner's conduct also constituted aggravated identity theft under Section 1028A01. Section 1028A01 applies when a defendant, during and in relation to any predicate offense, knowingly transfers, possesses or uses, without lawful authority, a means of identification of another person. The predicate offenses include, among many others, healthcare fraud. Section 1028AC4. Section 1028A01 carries a severe penalty, a mandatory minimum sentence of 2 years in prison in addition to the punishment for the predicate offense. According to the government, this is a clear aggravated identity theft case. The government argued at trial that Section 1028A01 was automatically satisfied because petitioner's fraudulent billing included the patient's Medicaid reimbursement number, a means of identification. The district court was less sure. This doesn't seem to be an aggravated identity theft case, the court explained, as the whole crux of this case is how petitioner was billing. This overbilling was criminal, but it wasn't aggravated identity theft. Nevertheless, the district court denied petitioner's post-trial challenge to his aggravated identity theft conviction, explaining that contrary Fifth Circuit precedent tied its hands. The court said that it hoped it would get reversed. On appeal, a Fifth Circuit panel affirmed. On rehearing en banc, a fractured court affirmed again. 5 judges who agreed with the government nonetheless acknowledged that under the government's reading of Section 1028A01, the elements of the offense are not captured or even fairly described by the words identity theft. 8 dissenting judges agreed on this point. This type of prosecution is not uncommon. The government has, by its own admission, wielded Section 1028A01 well beyond ordinary understandings of identity theft. One prosecution targeted a defendant who made a counterfeit handgun permit for another person, using that person's real name and at that person's request. Another involved unlicensed doctors who violated the law by issuing prescriptions that their actual patients would then fill at pharmacies. There was also a prosecution involving an ambulance service inflating its reimbursement rates by mischaracterizing the nature of the transports, saying that the patients had required stretchers when they had not. Yet another prosecution involved a defendant who provided massage services to patients to treat their pain, but improperly billed this as a Medicare-eligible physical therapy service. Many lower courts have responded to such prosecutions with more restrained readings of the aggravated identity theft statute. The Fifth Circuit did not. To resolve the conflict in the courts below, this court granted certiorari, and now vacates the judgment of the Fifth Circuit and remands. This case turns on two of Section 1028A01Z elements. Of the various possible ways to violate Section 1028A01, petitioner was convicted for using a patient's means of identification in relation to healthcare fraud. The parties offer competing readings of these two elements. The government reads the terms broadly and in isolation. On the government's view, a defendant uses a means of identification in relation to a predicate offense if the use of that means of identification facilitates or furthers the predicate offense in some way. As to uses, the government seems just to mean employs in any sense. Section 1028A(1) would thus apply automatically any time a name or other means of identification happens to be part of the payment or billing method used in the commission of a long list of predicate offenses. In other words, virtually all of the time. Petitioner, in response, offers a more targeted reading. For petitioner, using a means of identification in relation to a predicate offense requires a genuine nexus to the predicate offense. On this reading, the means of identification is at the crux of what makes the predicate offense criminal, rather than merely an ancillary feature of a payment method. When the underlying crime involves fraud or deceit, as many of Section 1028A's predicates do, this entails using a means of identification specifically in a fraudulent or deceitful manner. To illustrate, petitioner borrows a heuristic from the Sixth Circuit. The relevant language in Section 1028A01 covers misrepresenting who received a certain service, but not fraudulent claims regarding how or when a service was performed. In other words, fraud going to identity, not misrepresentation about services actually provided. Take an ambulance service that actually transported patients but inflated the number of miles driven. The crux of this fraud was how services were rendered. The patients' names were part of the billing process, but ancillary to what made the conduct fraudulent. In contrast, take the pharmacist who swipes information from the pharmacy's files and uses it to open a bank account in a patient's name. That misuse of the means of identification would be integral to what made the conduct fraudulent, because misrepresentation about who was involved was at the crux of the fraud. In deciding between the parties' readings, one limited and one near limitless, precedent and prudence require a careful examination of Section 1028A01Z text and structure. While uses and in relation to are, in isolation, indeterminate, the statutory context, taken as a whole, points to a narrower reading. In interpreting the scope of uses and in relation to, the court begins with those terms themselves. Both terms have been singled out by this court as particularly sensitive to context, and they do not, standing alone, conclusively resolve this case. Start with uses. As the court has observed more than once, the word use poses some interpretational difficulties because of the different meanings attributable to it. The ordinary or natural meaning of use is variously defined as to convert to one's service, to employ, to avail oneself of, and to carry out a purpose or action by means of. These various definitions of use imply action and implementation. Beyond that general concept, however, use takes on different meanings depending on context. And because it draws meaning from its context, we will look not only to the word itself, but also to the statute and the surrounding scheme, to determine the meaning Congress intended. For example, the federal arson statute only applies to buildings used in commerce or commerce-affecting activity. In that statutory context, the court distinguished between uses of a building as the locus of any commercial undertaking, and non-covered passive, passing, or ancillary uses of a building as collateral to obtain and secure a mortgage, or to obtain an insurance policy. It is statutory context, therefore, that determines what kind of active employment or conversion to one's service triggers Section 1028A(1)(z) harsh penalty. In relation to is similarly context-sensitive. If relate to were taken to extend to the furthest stretch of its indeterminacy, then for all practical purposes there would be no limits, as really, universally, relations stop nowhere. This language thus cannot be considered in isolation, and the court must go beyond the unhelpful text and the frustrating difficulty of defining this key term and look to statutory context. That the phrase refers to a relationship or nexus of some kind is clear, yet the kind of relationship required, its nature and strength, will be informed by context. The presence of two such context-dependent terms renders Section 1028A(1) doubly attuned to its surroundings. The parties' competing readings both fall within the range of meanings of uses and in relation to, taken alone. Resort to context is thus especially necessary here. Having found the key terms' use and in relation to indeterminate, the next step is to look to their surrounding words. After all, a statute's meaning does not always turn solely on the broadest imaginable definitions of its component words. Instead, linguistic and statutory context also matter. Even in cases where the literal language of the statute is neutral in isolation, reading the whole phrase can point to a more targeted reading. Such is the case here. Section 1028A01Z title and terms both point to a narrower reading, one centered around the ordinary understanding of identity theft. This cuts against the government's broad reading, which the government admits bears little relationship to the common understanding of identity theft. In contrast, a more targeted reading accurately captures the ordinary understanding of identity theft, where misuse of a means of identification is at the crux of the criminality. Start at the top, with the words Congress chose for Section 1028A's title, Aggravated Identity Theft. This court has long considered that the title of a statute and the heading of a section are tools available for the resolution of a doubt about the meaning of a statute. A title will not, of course, override the plain words of a statute. Yet here, the key terms are so elastic that they must be construed in light of the terms surrounding them, and the title Congress chose is among those terms. Even the government acknowledged that if the terms in Section 1028A01 are unclear, the title is a useful clue. Two additional points bolster this approach. First, the title here is not serving the unenviable role of pithily summarizing a list of complicated and prolific provisions. Section 1028A is a focused, standalone provision. Second, a title is especially valuable where it reinforces what the text's nouns and verbs independently suggest. As explained below, Section 1028A01Z text independently suggests a focus on identity theft. Indeed, this court has already once used Section 1028A's title and place in the statutory scheme to shed light on its text. In Flores-Figueroa v. United States, this court pointed out that a neighboring provision, Section 1028, carries the broad title Fraud and Related Activity in connection with identification documents, authentication features, and information. Section 1028A, in contrast, is far more targeted, using the words identity theft. That Congress separated the identity fraud crime from the identity theft crime in Section 1028A suggests that Section 1028A is focused on identity theft specifically, rather than all fraud involving means of identification. Given that, it is abundantly clear why the government urges the court to ignore the title. The government's broad reading, covering any time another person's means of identification is employed in a way that facilitates a crime, bears little resemblance to any ordinary meaning of identity theft. Consider again an unlicensed doctor who fills out a prescription actually requested by a patient. No one would call that identity theft. Even judges below who agreed with the government's reading of Section 1028A01, and ultimately the government itself, acknowledged that its reading of Section 1028A01 does not fairly capture the ordinary meaning of identity theft. Nor is the difference just around the edges. The government's reading would, in practice, place garden variety overbilling at the core of Section 1028A. Instead, identity theft has a focused meaning. One dictionary defines identity theft as the fraudulent appropriation and use of another person's identifying data or documents as a credit card. Another similarly offers the unlawful taking and use of another person's identifying information for fraudulent purposes, specifically a crime in which someone steals personal information about and belonging to another, such as a bank account number or driver's license number, and uses the information to deceive others. This supports a reading of in relation to where use of the means of identification is at the crux of the underlying criminality. These definitions refer to offenses built around what the defendant does with the means of identification in particular. In other words, the means of identification specifically is a key mover in the criminality. This central role played by the means of identification, which serves to designate a specific person's identity, explains why we say that the identity itself has been stolen. This helps explain why the examples resulting from the government's theory do not sound like identity theft. If a lawyer rounds up her hours from 2.9 to 3 and bills her client using his name, the name itself is not specifically a source of fraud. It only plays an ancillary role in the billing process. The same is true for the waiter who substitutes one cut of meat for another. We might say the filet mignon's identity was stolen perhaps, but not the diner's. This understanding of identity theft also supports a more targeted definition of uses. The word use appears in these definitions with a specific meaning. Identity theft encompasses when a defendant uses the information to deceive others, and the fraudulent use of a means of identification. In other words, identity theft is committed when a defendant uses the means of identification itself to defraud or deceive. This tracks the Sixth Circuit's heuristic. When a means of identification is used deceptively, this deception goes to who is involved, rather than just how or when services were provided. Use of the means of identification would therefore be at the locus of the criminal undertaking, rather than merely passive, passing, or ancillary employment in a crime. On top of that, Section 1028A's title is not just identity theft, but aggravated identity theft. Typically, an aggravated offense is one made worse or more serious by circumstances such as violence, the presence of a deadly weapon, or the intent to commit another crime. This suggests that Congress had in mind a particularly serious form of identity theft. Yet the government's reading would apply an aggravated label to all manner of everyday overbilling offenses. Of course, Congress, like Humpty Dumpty, has the power to give words unorthodox meanings. Yet where the government argues for a result that the English language tells us not to expect, we must be very wary of the government's position. The title suggests identity theft is at the core of Section 1028A1. On the government's reading, however, everyday overbilling would become the most common trigger for Section 1028A1's severe penalty. This would turn the core of worse or more serious identity theft into something the ordinary user of the English language would not consider identity theft at all. Section 1028A's list of predicate offenses points to yet another stumbling block for the government's broad reading. Section 1028A1 is an enhancement, and a severe one at that. It adds a 2-year mandatory prison sentence onto underlying offenses that do not impose a mandatory prison sentence of any kind. This prevents sentencing judges from considering the severity of the offense, even if the amount of money involved was quite small or there are other mitigating factors. Interpretation of Section 1028A1 should thus reflect the distinction between the aggravated identity theft crimes that Congress sought to distinguish for heightened punishment and other crimes. Far from distinguishing, the government's reading collapses the enhancement into the enhanced. Here, the government claims that because petitioner's overbilling was facilitated by the patient's Medicaid reimbursement number, Section 1028A1 automatically applies. Patient names or other identifiers will, of course, be involved in the great majority of healthcare billing, whether Medicare for massages or for ambulance stretcher services. Patient names will be on prescriptions, and patients committing fraud on their own behalf will often have to include the names of others on their forms, such as doctors or employers. Under the government's own reading, such cases are automatically identity theft, independent of whether the name itself had anything to do with the fraudulent aspect of the offense. Nor are these implications confined to healthcare. Section 1028A1Z predicates include a vast array of offenses, including wire fraud and mail fraud. The government's boundless reading of uses and in relation to would cover facilitating mail fraud by using another person's name to address a letter to them. Even beyond that, names or other means of identification are used routinely for billing and payment, whether payment apps, credit and debit cards, a bill sent by mail, or an invoice sent electronically. So long as the criteria for the broad predicate offenses are met, the government's reading creates an automatic 2-year sentence for generic overbilling that happens to use ubiquitous payment methods. A far more sensible conclusion from the statutory structure is that Section 1028A1Z enhancement is not indiscriminate, but targets situations where the means of identification itself plays a key role, one that warrants a 2-year mandatory minimum. This points once more to a targeted reading, where the means of identification is at the crux of the underlying criminality, not an ancillary feature of billing. If more were needed, a final clue comes from the staggering breadth of the government's reading. This court has traditionally exercised restraint in assessing the reach of a federal criminal statute. This restraint arises both out of deference to the prerogatives of Congress and out of concern that a fair warning should be given to the world in language that the common world will understand of what the law intends to do if a certain line is passed. After all, crimes are supposed to be defined by the legislature, not by clever prosecutors riffing on equivocal language. Time and again, this court has prudently avoided reading incongruous breadth into opaque language in criminal statutes. In Van Buren v. United States, the far-reaching consequences of the government's reading underscore the implausibility of the government's interpretation. In Marinello, the court rejected the government's reading of a statute about obstructing administration of the tax code that would have swept in the person who pays a babysitter $41 per week in cash without withholding taxes, as well as someone who leaves a large cash tip in a restaurant, fails to keep donation receipts from every charity to which he or she contributes, or fails to provide every record to an accountant. Nor was all such conduct innocent, as the statute required an individual to act corruptly. Even still, had Congress intended to sweep so far, it would have spoken with more clarity than it did. In Yates, the court held that the government's unrestrained reading would have turned a provision focused on records and documents into an all-encompassing ban on the spoliation of evidence that would sweep within its reach physical objects of every kind, including a fish. Had Congress set out to do so, one would have expected a clearer indication of that intent. So too here, the government's reading would sweep in the hour-inflating lawyer, the stake-switching waiter, the building contractor who tacks an extra $10 onto the price of the paint he purchased. So long as they used various common billing methods, they would all be subject to a mandatory 2 years in federal prison. To say that such a result is implausible would be an understatement, because everyday overbilling cases would account for the majority of violations in practice. The government's reading places at the core of the statute its most improbable applications. Finally, the government makes a familiar plea. There is no reason to mistrust its sweeping reading, because prosecutors will act responsibly. To this, the court gives a just as familiar response. We cannot construe a criminal statute on the assumption that the government will use it responsibly. To rely upon prosecutorial discretion to narrow the otherwise wide-ranging scope of a criminal statute's highly abstract general statutory language places great power in the hands of the prosecutor. This concern is particularly salient here. If Section 1028A01 applies virtually automatically to a swath of predicate offenses, the prosecutor can hold the threat of charging an additional 2-year mandatory prison sentence over the head of any defendant who is considering going to trial. All the points above are different wells drawing from the same source. The court need not decide whether any of these points, standing alone, would be dispositive. Taken together, from text to context, from content to common sense, Section 1028A01 is not amenable to the government's attempt to push the statutory envelope. A defendant uses another person's means of identification in relation to a predicate offense when this use is at the crux of what makes the conduct criminal. To be clear, being at the crux of the criminality requires more than a causal relationship, such as facilitation of the offense or being a but-for cause of its success. Instead, with fraud or deceit crimes like the one in this case, the means of identification specifically must be used in a manner that is fraudulent or deceptive. Such fraud or deceit going to identity can often be succinctly summarized as going to who is involved. Here, petitioner's use of the patient's name was not at the crux of what made the underlying overbilling fraudulent. The crux of the healthcare fraud was a misrepresentation about the qualifications of petitioner's employee. The patient's name was an ancillary feature of the billing method employed. The Sixth Circuit's more colloquial formulation is a helpful guide, though like any rule of thumb it will have its limits. Here, however, it neatly captures the thrust of the analysis, as petitioner's fraud was in misrepresenting how and when services were provided to a patient, not who received the services. Because petitioner did not use the patient's means of identification in relation to a predicate offense within the meaning of Section 1028A01, the judgment of the Court of Appeals is vacated, and the case is remanded for further proceedings consistent with this opinion. It is so ordered. Justice Gorsuch, concurring in the judgment. Whoever among you is not an aggravated identity thief, let him cast the first stone. The United States came to this court with a view of Section 1028A01 that would affix that unfortunate label on almost every adult American. Every bill splitter who has overcharged a friend using a mobile payment service like Venmo. Every contractor who has rounded up his billed time by even a few minutes. Every college hopeful who has overstated his involvement in the high school glee club. All of those individuals, the United States says, engage in conduct that can invite a mandatory 2-year stint in federal prison. The court today rightly rejects that unserious position. But in so holding, I worry the court has stumbled upon a more fundamental problem with Section 1028A01. That provision is not much better than a Rorschach test. Depending on how you squint your eyes, you can stretch or shrink its meaning to convict or exonerate just about anyone. Doubtless, creative prosecutors and receptive judges can do the same. Truly, the statute fails to provide even rudimentary notice of what it does and does not criminalize. We have a term for laws like that. We call them vague, and in our constitutional order, a vague law is no law at all. The Aggravated Identity Theft Statute stipulates that whoever, during and in relation to any felony violation listed in a later subsection, knowingly transfers, possesses or uses, without lawful authority, a means of identification of another person shall, in addition to the punishment provided for such felony, be sentenced to a term of imprisonment of 2 years. Today, the court sets out to determine what conduct that law reaches. It is, as the court acknowledges, no easy task. Both the term use and the phrase in relation to can support a multitude of possible meanings. They of course imply action and implementation. Beyond that general concept, however, we must fend for ourselves based only on limited contextual clues. The United States offers up a rapacious interpretation that would require only the use of the means of identification to facilitate or further the predicate offense in some way. Admittedly, this reading falls within the range of plausible meanings the statute could support, but so too do other readings, ones that require a more demanding nexus between the means of identification and the underlying misconduct. For many of the reasons the court gives, and more besides, I agree that we must adhere to those more restrained offerings. The United States maximalist approach has simplicity on its side. Yes, an everybody is guilty standard is no challenge to administer. But the Constitution prohibits the judiciary from resolving reasonable doubts about a criminal statutes, meaning by rounding up to the most punitive interpretation its text and context can tolerate. That insight alone means Mr. Dubin's Section 1028A01 conviction cannot stand. Unfortunately, our opinion cannot end there. Having told lower courts how not to read the statute, we owe them some guidance as to how they should read it. That is where the real challenge begins. Drawing on contextual clues and rules of statutory interpretation, the court concludes that a violation of Section 1028A01 occurs whenever the use of the means of identification is at the crux of the underlying criminality. In other words, the means of identification specifically must be in some way a key mover in the criminality. Put still another way, the means of identification must play the, or maybe a, central role in the commission of the offense. Setting aside some definite article inconsistency, those formulations all sound sensible enough. On closer review, however, they present intractable interpretive challenges of their own. When, exactly, is a means of identification at the crux, a key mover, or a central role player in an offense? No doubt the answer turns on causation, or at least causation often helps to answer the question. The court agrees but stresses that a causal relationship of any kind will not suffice. At the same time, however, it studiously avoids indicating whether the appropriate standard is proximate cause, or something else entirely novel, all of which gives rise to further questions. In virtually every fraud, a means of identification plays some critical role in the fraud's success. Good luck committing a mail or wire fraud, for instance, without relying heavily on the name of the victim and likely the names of other third parties. Just how much causation must a prosecutor establish to sustain a Section 1028A01 conviction? For that matter, how does one even determine the extent to which a means of identification caused an offense, as compared to the many other necessary inputs? The court supplies no firm answer. Instead, it leans on various illustrations that only highlight the difficulties inherent in this exercise. Take, for instance, the court's assurance that a waiter who serves flank steak, but charges for filet mignon using an electronic payment method, has not committed aggravated identity theft. Why not, exactly? In one sense, the means of identification, the credit card, lies at the crux of the fraud. The restaurant uses it to charge the customer for a product it never supplied. Maybe that feels less distasteful than a scenario in which an overseas hacker steals an individual's credit card information and deploys it to order luxury goods on Amazon. But the Constitution's promise of due process means that criminal statutes must provide rules knowable in advance, not intuitions discoverable only after a prosecutor has issued an indictment and a judge offers an opinion. Not yet convinced? Consider some tweaks to the court's hypothetical. Suppose that, instead of misrepresenting the cut of its steaks, a restaurant charged a customer for an appetizer he ordered that never arrived. What about an appetizer he never ordered? An additional entree? Three plus a $5,000 bottle of Moet? How about a Boeing 737? Now suppose the restaurant ran the customer's credit card for the same steak twice. What if it waited an hour to do so? A day? A year? What if the waiter gave the credit card information to a different employee at the same restaurant to run the charge? A different employee at a different restaurant? What if the restaurant sold the customer's credit card information on the dark web, and another restaurant ran the card for filet mignon? On the court's telling, the crux of the fraud in some of these examples lies merely in how and when services were provided, while in others the crux involves who received the services. But how to tell which is which? The court's crux test seemingly offers no sure way through this blizzard of hypotheticals, nor is that because I have cherry-picked hard cases. Scenarios like these, and variations of them, illustrate the sorts of problems that invariably arise in even simple Section 1028A01 cases involving bogus restaurant bills. Other contexts can present still greater complications and still deeper uncertainties. The problem we face, then, is not that Section 1028A01 presents some hard cases at its edges. The problem is this statute has no easy cases. Really, you could spend a whole day cooking up scenarios, ranging from the mundane to the fanciful, that collapse even your most basic intuitions about what Section 1028A01 does and does not criminalize. Try making up some of your own and running them by a friend or family member. You may be surprised at how sharply instincts diverge. For the less adventurous, consider just the facts of the case now before us. On one framing, it seems outrageous to convict Mr. Dubin of aggravated identity theft. After all, the patient did, at one point, receive psychological testing. So you might say, as the court does, that Mr. Dubin lied only about the qualifications of the individual who provided those services and the date on which they occurred. But on another framing, the patient's identity was a key mover, perhaps even at the crux of the fraud. Mr. Dubin could not have successfully billed the insurance provider without accurately offering up some specific patient's name and information. Nor, as the United States notes, could Mr. Dubin have simply drawn a random name from a hat. Rather, His fraud depended on purloining the specific identity of a Texas Medicaid enrollee who had at least 3 hours of psychological testing reimbursement left in his or her account. Along the way, Mr. Dubin compensable psychological services. From the patient's perspective, Mr. Dubin's use of his means of identification could hardly feel ancillary. As an abstract exercise, debating fact patterns like these may seem good fun, but there is nothing entertaining about a 2-year mandatory federal prison sentence. Criminal statutes are not games to be played in the car on a cross-country road trip. To satisfy the constitutional minimum of due process, they must at least provide ordinary people with fair notice of the conduct they punish. And, respectfully, I do not see how Section 1028A01 can clear that threshold. Under the court's crux test, no boundary separates conduct that gives rise to liability from conduct that does not. And it appears I share this concern with the very lower court judges who will have to apply this standard prospectively. As even many of the Fifth Circuit dissenters below warned, the sort of facilitation standard the court today adopts, with its incidental/integral dividing line, is unworkable because it lacks clear lines and a limiting principle. In the end, it is hard not to worry that the court's crux test will simply become a fig leaf for judges' and jurors' own subjective moral judgments about whether, as the court itself puts it, the defendant's crime is one that warrants a 2-year mandatory minimum. I do not question that the court today has done the best it might to make sense of this statute. It's just that it faces an impossible task. In the past, when this court has grappled with similar statutory language, it has done so in contexts where the relevant terms could carry only a few possible and comparatively fixed meanings. For example, when it comes to the use of a firearm in relation to a crime of violence, the presence of a gun could be a but for cause of, or a necessary ingredient of the offense, used, for example, as compensation in an exchange for illicit drugs. Or the gun could be used as a weapon by being discharged or brandished. Because both those interpretations are relatively bounded and understandable, this court could use principles of statutory interpretation to choose between them. The same holds true for many of the other statutes the court, mistakenly, frets I would call into doubt. The same cannot be said for Section 1028A01 though. There are an uncountable number of ways in which an individual could use the means of identification of another to commit fraud. That list covers everything from including a victim's name in the subject line of a fraudulent email, to misrepresenting information on a loan form involving a cosigner, to putting on a wig and walking into a bank with a fake ID, and no obvious neutral rule exists to separate those uses that violate Section 1028A01 from others that do not. In this way, Section 1028A01 is not just an ambiguous statute, one that does define prohibited conduct with some precision, but that is subject to 2 or more different interpretations. Instead, it is a vague statute, one that does not satisfactorily define the proscribed conduct at all. I do not write this opinion as wish-casting. Perhaps, by applying the court's crux test, lower courts will achieve a consistency that has, to date, eluded them. Or perhaps they will, prompted by today's decision, locate a previously unseen path through this statutory quagmire. But I would not hold my breath. Section 1028A01 simply does too little to specify which individuals deserve the inglorious title of aggravated identity thief. That is a problem Congress alone can fix. Until it does, I fear the issues that have long plagued lower courts will persist. And I will not be surprised if someday, maybe someday soon, they find their way back here. Thanks for listening. This podcast is not affiliated with the United States Supreme Court or its staff in any way. The summary of this opinion given in the introduction was taken from the summary provided at oyez.org. Any mistakes in the opinion you just heard should be attributed to this podcast. If you would like to support my efforts to make Supreme Court opinions available to the public, please subscribe. Thank you.